May it please the Honorable Court, my name is Imad Hilal and I am presenting an appeal where Mr. Jimmy Boy is the appellant and Rex are the defendants. My lord, I am going to start from the introduction which is mentioned on the page number 1 of my skeleton arguments. My lords, this is an appeal on behalf of Mr. Jimmy Boy under Section 1 of Criminal Appeal Act 1968, following a conviction of supplying heroin under the Misuse of Drugs Act 1971, in which Judge Horace Hooligan summing up raises concerns. My lord, I am requesting you to look at the para number 2 of my skeleton argument where the relevant facts of the case are mentioned. My lord, Mr. Jimmy the appellant was convicted after a jury decision of 12-2 after a 5-day trial at Lieutenant Crown Court. My lord, the trial judge Hooligan summary, particularly considering the burden of proof and Jimmy defense of the unintentionally supplying heroin, says arose concerns. My lord, during the examination of Mr. Jimmy denied knowing anything about the contents of the box, while the prosecution argued that the Jimmy must prove that he did not know what was in the box. Mr. Jimmy claims that the box he carried was thought to contain medical supplies for London Hospital in Belgravia. My lord, and that he also claimed that he was given strict instruction not to open it by those who asked him to deliver it. My lord, I am requesting you to look at the para number 3 of my skeleton argument, page 1, where the grounds of appeal are mentioned. My lord, the first ground of appeal is misdirection by judge on standard of proof. My lord, the trial judge mislead the jury and undermines the true legal standard of proof by comparing the higher standard of proof required in criminal cases known as beyond reasonable doubt to everyday appears doubt. My lord, moving forward to the ground number 2 of this skeleton argument, which is mentioned as prejudicial statement. The trial judge harsh statement about human rights and his personal beliefs about the sentence that such people deserve life imprisonment, which influence the jury decisions. My lord, this is just his personal opinion and not mentioned in the law, which can confuse the jury. My lord, moving forward to the ground number C of the skeleton argument, which is mentioned as Misuse of Drugs Act 1971 provisions. My lord, the trial judge misused the Misuse of Drugs Act 1971 provision by neglecting to appropriately advise the jury on the defendant's legal burden to prove that he did not know what was inside the box. My lord, the next ground of appeal is reliance on quantity as evidence of intention. The trial judge incorrectly directed on the sufficient amount of heroin as evidence of intention to supply on the basis of contentions by the prosecutions. Your Honors, may I kindly request to put our attention to the page number 3 of the skeleton arguments where crucial points await our considerations. My lord, look at to the ground number E on page 2 of the skeleton arguments, which is mentioned as failure to address the fundamental thrust of the defendant's defense. My lord, the trial judge failed to consider the appellant's fundamental defense, which was based on his lack of information about the content of the box, whether he intended to deliver the heroin or he is just doing his duty. My lord, moving forward to the ground number F of the skeleton argument, which is mentioned as violation of Article 6 of PCHR right to fair trial. The trial judge, the right to a fair trial is guaranteed by Article 6 of PCHR. The value outlined in Article 6 are incompatible with the trial judge mishandling on the burden of proof and his disrespect for human rights by stating that I don't care much about for human rights. My lord, I want your attention for the ground G of this skeleton argument, which is mentioned as failure to direct jury to ignore his personal views. My lord, the trial judge also fails to direct the jury about the common law rule to ignore his personal views while summing up the case. My lord, moving forward to the ground number H of the skeleton argument, which is mentioned as residual direction of Court of Appeal. My lord, the Court of Appeal have the power to set aside a conviction where they felt the conviction is unfair or unsafe, even if there is no ground of appeal. My lord, these are all the grounds which, on the basis of which Mr. Jimmy claims that his conviction could be set aside. My lord, I want your attention for the para number 2 of my skeleton argument, page 1, where submissions of the above grounds are mentioned. My lord, Look at to the submission number 1, which is mentioned is misdirection by judge on standard of proof. The judge comparison of beyond reasonable doubt to everyday appears created confusion and misrepresent the higher standard of proof required in criminal cases. The misstatement may have alerted the jury perceptions of their role in evaluating the evidence. My lord, as established in Walmington versus DPP, where Walmington was charged with a murder of his wife, and he claimed in examination that the shooting was just accidentally and not intentionally. My lord, however, the jury found him guilty, but the House of Lords held that the prosecution bears the whole burden of establishing guilt beyond reasonable doubt. In addition, the case emphasized another principle which is known as innocent until proven guilt. My lord, furthermore, R versus Kingston 1994 established the legal standard of beyond reasonable doubt requires a significantly higher standard of proof, emphasizes moral certainty in criminal proceeding. Adhering to this high standard is especially in drug-related offenses because of the serious implication of drug supply and the potential impact on the individual communities, as emphasized in the Misuse of Drugs Act 1971. My lord, I want your attention for the ground number B of the skeleton argument, which is mentioned as prejudicial comments. My lord, the trial judge's statement demonstrating a lack of regards for human rights and his conviction that those guilty of drug-related offenses deserve life imprisonment are highly prejudicial. It was stressed in R versus Failure 2001 that the judge remark must not potentially sway the jury verdict. Such remarks cast doubt on the judge's impartiality and undercut the idea of the fair and unbiased trial. My lord, look at to the submission number C of the skeleton argument on page 2, which is mentioned as Misuse of Drugs Act 1971 provision. The trial judge made a serious mistake when he failed to give apprecious instructions on the legal burden imposed on the defendant under the Misuse of Drugs Act 1971. My lord, according to R versus Edwards 1996, the burden is not absolute and must be properly explained to the jury. My lord, the jury may have reached an unjust decision due to their misrepresentation of the law. As a result, the judge's insufficient instructions. My lord, I want your attention for the submission number D of the skeleton argument, which is mentioned as reliance on the quantity as evidence of intention. My lord, the trial judge erroneous reliance on the prosecution's stance on the quantity of heroin is a proof of intention to supply as legally unsound, because as held in R versus Johnson 1988, and where Johnson was charged with two different charges. One of them is firearm, and the jury found him guilty. However, the court held that the law requires that intention be proven by taking into account more than just quantity. My lord, in addition, the Court of Appeal held in R versus Whitehead 1983 that the amount of drugs by itself does not prove intention to supply. Furthermore, my lord, the trial judge also fails to define the difference between the ecstatic and mens rea to the jury, because the amount only prove the ecstatic while intention cannot be proven by the quantity as per the above mentioned cases. My lord, I am requesting you to move forward to the page number 3 of the skeleton argument, where more submissions are mentioned. My lord, look at the submission number E of page 3, which is mentioned as failure to address the fundamental thrust of the defendant's defense. My lord, Jimmy asserted a defense centered on his lack of information about the box content and believed it contains medical supplies for a hospital. However, it appears that the trial judge did not adequately address the core argument presented by the defense and failed to properly appraise the jury of Jimmy's defense. My lord, it is suggested that the conviction should be quashed as in R versus Stepson 1979 and R versus Osborne 2020, where similar failures lead to conviction being quashed. My lord, I am requesting you to look at the submission number F of the skeleton argument on page 3, which is mentioned as violation of Article 6 of ECHR. My lord, the trial judge misguiding approach to the burden of proof and contempt for human rights violated the right to fair trial protected by Article 6 of ECHR. My lord, as you know, the UK have adopted the ECHR by passing Human Rights Act 1998, so the court should take care of Article 6. Furthermore, my lord, recently R versus Lord Chancellor 2020, UKSC 3 have emphasized the role that the fair trial is the right of every person and the court are bound to provide it to everyone. My lord, I want your attention for the ground number G of the skeleton argument, which is mentioned as failure to direct jury to ignore his personal views. My lord, the trial judge failed to direct the jury to ignore his personal view during giving statement to the jury, especially those suggesting prejudicially statement against the defendant. Like, I personally believe that such people deserve life imprisonment and I don't care much about the human rights. My lord, as in R versus Dow 2003, it was established that the judge have the duty to instruct the jury to ignore his view in order to prevent potential prejudices from affecting the verdict. My lord, the trial judge did not do this in the trial of Mr. Jimmy, and we believe that this affect the verdict of jury. My lord, I want your attention for the last submission of the skeleton argument, which is mentioned as the residual direction of Court of Appeal. My lord, Judge or his hooligan instruction have unfairly influenced the jury verdict, which is really disrupted with inadequate summing up as in R versus D 2020. My lord, to guarantee a fair trial, the court should set aside the conviction by applying residual direction. My lord, the residual direction allows the court to make decision based on the principle of justice and fairness, even if there is no specific guideline to expect cover these circumstances. That's it, my lord. These are my arguments for the Mr. Jimmy Boyle, and this the trial judge errors while summing up raise grave concerns of the legitimacy of the conviction. Therefore, it is humbly submitted to the honorable court that the conviction of Mr. Jimmy may be grossly set aside. Thank you, Your Honors.